start, sir?
Yeah, we can start.
Good evening. A warm welcome to all of you to the webinar series hosted by Advocates Association, Bengaluru. We have with us today Mr. Mohan V. Katarki, Senior Advocate, Supreme Court of India. Sir, it's an honor to have you with us today, sir. Welcome to the webinar.
Thank you.
It's time for me to introduce the speaker. Mr. Mohan Katarki is a designated Senior Advocate by the Supreme Court of India. He has represented the state of Karnataka, Odisha, Punjab, and Kerala in several important transboundary water disputes before the Supreme Court of India and interstate water dispute tribunals. Mr. Katarki was a member of the Academic Council of the National Law School of India, University, Bangalore between 2005 and 2008. He was also the member editorial advisory board of the Students' Law Review, published by the Karnataka State Law University, and Bangalore University Law Journal, published by the Bangalore University. He is a member of the Board of Management and Planning, Karnataka State Law University, Hubli. He is also a patron and member of the Executive Committee of the Bar Association of India at New Delhi. Mr. Katarki has attended a number of national and international conferences and has also delivered a number of lectures both abroad as well as in India. He has also published a large number of articles, papers, and blogs. So once again, on behalf of Advocates Association Bangalore, I extend a warm welcome to you, sir.
Sir, illi bedakal barutte. Rangnath. ಅಧ್ಯಕ್ಷರೇ ಸರ್ ಇಲ್ಲಿ ಬರುತ್ತೆ ನೋಡಿ ಬಂತಾ
ಪ್ರವೀಣ್ ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿದ್ದೀರಾ ರಂಗನಾಥ್ ಸರ್ನ ಪ್ರವೀಣ್
ಮಾಡಿದ್ದೀನಿ
ರಂಗನಾಥ್ ಸರ್ ಅನ್ಮ್ಯೂಟ್ ಆಗಿಲ್ಲ ಸೆಕ್ರೆಟರಿ ಸರ್ ನಿಮ್ದು ಆಗಿಲ್ಲ ಅನ್ಮ್ಯೂಟ್ ಆಗಿಲ್ಲ
ಸೆಕ್ರೆಟರಿ ಸರ್ದು ಆಗಿದೆ ಒಂದು ನಿಮಿಷ ಸೆಕ್ರೆಟರಿ ಸರ್ ಮಾತಾಡಬಹುದು
ಸರ್ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೋಬೇಕು ರಂಗನಾಥ್ ಸರ್
ಅವ್ರದ್ದು ಅನ್ಮ್ಯೂಟ್ ಆಗ್ತಾ ಅವ್ರು ಮಾಡ್ತಾ ಇಲ್ಲ ಸೆಕ್ರೆಟರಿ ಸರ್ದು ಅನ್ಮ್ಯೂಟ್ ಆಗಿದೆ ಅವ್ರು ಆಕ್ಚುಲಿ ಮಾತಾಡ್ಬೋದಿಲ್ಲ ಅಂದ್ರೆ
ರಂಗನಾಥ್ ಸರ್ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೋಬೇಕು
ಮೋಸ್ಟ್ಲಿ ನೆಟ್ವರ್ಕ್ ಪ್ರಾಬ್ಲಮ್ ಇರಬೇಕು ಅವ್ರ ಹತ್ರ
ನೆಟ್ವರ್ಕ್ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಅನ್ಸುತ್ತೆ ಗಂಗಾಧರಯ್ಯ ಸರ್ ಕೂಡ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ ಸೊ ಓವರ್ ಟು ಯು ಸರ್ president and secretary apparently they had a meeting I think there is some network issue so they will be joining us little later. I'm sorry about it, so over to you.
No problem. Yeah, thank you. May I welcome you all to this webinar. I especially thank the President of the Bangalore Bar Association for inviting me to speak on this occasion. The topic chosen for today is historical evolution of transboundary water disputes in India. When I was asked to speak on the interstate water disputes in India, initially I was a little hesitant because I've been speaking, of course, on the transboundary water disputes in the context of international law, but I have not been speaking in the context of interstate water disputes, primarily for the reason that I have been appearing for one or the other state in most of the interstate water disputes. But when Rangnath insisted that the topic should be interstate, as that might be of interest to the members of the bar, then I decided to put it in this fashion as historical evolution of transboundary water disputes in India. Friends, The evolution of water disputes is not ancient in India. In fact, nowhere. The water dispute started in the last 200 years for several factors. These are the rivalry between upper and lower riparian states, growth of civil engineering technology, particularly the technology of constructing high dams, then political consciousness, which was not there until the seeds of democracy were sown in the 19th century. When the water dispute started initially, it was a intense discussion between the upstream and downstream states. Even after 200 years, most of the disputes arise in the context of upstream state trying to construct a dam and downstream state trying to assert its historical rights. You may ask me, why does it happen that when upstream state constructs a dam or when it decides to utilize the water by diversion or by digging new canals, why do the lower riparian states object? Why can't it happen the other way? The reason is this: as all of you know, water flows by gravity from upstream to downstream. So what? There is a reason for this. Historically, the waters were utilized by the downstream state near the delta. Every river that you talk about in the world has a typical topography. The river rises in the mountains, then it flows in the plain. Finally, it enters the deltaic portion. That is the portion of the river which is about 100 or 200 kilometers from the sea, where the river starts breaking into the various channels. It is called river braiding in geological terms. It happens because the elevation level comes down. It will be hardly about 100 meters above the sea level. You must have heard about Delta of Nile, Mississippi Delta, Brahmaputra and Ganges Delta, Mekong Delta, famous Indus Delta, and back home, our own Kaveri Delta, Krishna Delta, Mahanadi Delta. These deltas were fortunate to have the water made available to them by natural flow from the upstream state. As a result of this available water, and for the reason that the land was flat in the downstream, the irrigation in these areas was natural. So for the last 2000 years or more, or you can say since the advent of agriculture, the deltas have been utilizing water. There are no man-made canals or barrages. They did it in the natural system of drainage, natural drainage system. In contrast to this, what happened is the upstream states enjoyed the flow of water but that remained only a scenic enjoyment, unfortunately. They could not utilize the water because in those days, there was no technology to dam the water and transfer it to the distant areas by cutting the canals through the ridge lines. Once the technology became available in the 19th century, the growth of civil engineering technology, the construction of high dam became possible. Naturally, the upstream state started constructing the dams. This construction of dams by the upstream states to utilize the water led to the conflict between the upper state and the downstream state. The downstream states asserted the rights in the water by reference to prescription, customs, etc. Even the doctrine of prior appropriation was applied. So in this conflict between upstream and downstream, between the new users of water in the upstream and the old users of water in the downstream, between the existing right holders and the new right holders, the law had to evolve to address the disputes. Initially, when these disputes arose in the international field, particularly the international law started growing after the Westphalia Treaty in the 16th century. The initial response was that the states have sovereign rights to utilize all the water that is available in its territory, regardless of injury or the effect it causes on the downstream state. This is called incident of sovereignty. Attorney General of United States of America, Harmon, is a proponent of this doctrine in one of the first major water dispute that arose between United States of America and the downstream Mexico. Later, as a rival to this doctrine of sovereignty, the riparian doctrine came up, which was initially a private law and adopted into the international law. This riparian doctrine is exactly opposite of what Harmon doctrine or doctrine based on sovereignty spoke. According to this riparian doctrine, the water has to flow down in the state of nature. That means upstream state cannot utilize the water beyond what is necessary for primary uses like drinking water. This gave practically entire river to the downstream states. By this process, naturally, the downstream states, which had a large delta and large commitment, were able to, or they thought that they could protect their rights. When both the doctrines became an obstacle in the resolution of a dispute or to arrive at a just solution, the doctrine of equitable apportionment emerges. It started in the United States of America in the federal disputes. Justice Holmes, in one of his judgment in the dispute between state of New York and state of New Jersey, He very beautifully puts it. The upstream state has a right to cut off water as it pleases. The downstream state cannot expect the water to flow down in the course of nature. Both these extreme doctrines will not find a solution. And Justice Holmes said, both the states have to divide the water depending upon their needs. He said they have vital interest in the waters. So, under this doctrine of equitable apportionment, the states have equal rights to water, but equal rights or equality does not mean equal division of water. It is a division of water based upon the needs of the state. In establishing the needs of the states, several parameters or several guidelines have evolved in the course of history. The International Law Association has crystallized these guidelines in 1966, and they are called Helsinki Rules. They are later modified by Berlin Rules of 2004. These crystallized guidelines are based upon series of decisions of the US Supreme Court and arbitrations elsewhere in the world. So, in the transboundary water disputes, which are between the two sovereign states, we call them international water disputes. If they are in the federal context, that is within the federal state, we call them federal disputes. But the principles or the rule of law that is applied is almost the same. That is doctrine of equitable apportionment. Having said this, broadly, let me proceed how it all started in India. As I said, the water disputes are not more than 200 years old, and it applies to India also. When the high dam technology was brought to India by the British power, the disputes really started in India or started erupting. The India which you see today and I see was different before 1947. Not only that, India then consisted of Pakistan and Bangladesh, which were separated under the partition theory, but the very India was different in a sense. It was called British India and Indian states. British India was a part of India which was ruled or administered directly by the British Crown in England. The Crown was directly responsible to the people. The British Parliament had the jurisdiction to pass the laws with regard to the British India. Though India was not treated as part of the territory of United Kingdom, but it was still a part of the United Kingdom in a sense, as a colonial territory. The ultimate head of the India, British India, was Secretary of State for India. He was the member of British cabinet. So this is British India. Now let's see what is this Indian states. Indian states were the states ruled by the princes. There are several Maharajas and Nawabs who were the sovereign powers and who ruled over these states. But British exercised control over these princes, and that controlling power was famously called as paramountcy. If you look at the relationship between the princely states and the British crown, or the legal status of the princely states, they are not sovereign in the real sense. They were semi-sovereign, one can say. Many international commentators have described them as feudatories of the British crown. Some have said they are vassals, so on. In short, these Indian states were bit autonomous internally in the domestic matters, but in respect of the external matters, they had no freedom. The entire power vested with the British crown to decide on their behalf what relation they should have with other states, etc. Even in the internal matters, the advice of the British crown was almost a law. It was binding on the rulers. So we had two Indias, one British India, another princely states. And these princely states were not few in number. They were nearly about 500. But the most important princely states were, which were bigger in size, starting with Hyderabad, Mysore, Baroda, Kashmir, Gwalior, and so on. So now coming to water disputes, how the dispute started. Initially, there were no disputes between the provinces or presidencies of the British India. The British India was almost a unitary state under the Government of India Act of 1858. Whereas, in relation to princely states, things were different. So when the water disputes arose between the British India or a province of British India and the princely states, it became an important issue as to how to resolve them. As I said, the princely states were sovereign states, but partly their sovereignty was surrendered to the British Crown, who was the ultimate power holder, and that is called paramountcy. On the other hand, the British India was the territory directly administered by the British through the Secretary of State and the Governor General and the governors of the states. So when the dispute started between one part of India, which was directly ruled by the British, and another part of India, which was indirectly ruled by the British, how to resolve these disputes. One of the first dispute was the dispute relating to Kaveri. Sometime in 1890 or 1888, when Mysore proposed several schemes to dam the water for utilization in the drought areas, the Madras objected, that is, British India and downstream state. In fact, the dispute between both Mysore and Madras goes back to 1807 itself, when they first time objected. So when they objected again in 1888-89, several rounds of discussions were held between the princely state of Mysore, represented invariably again by the British resident in Mysore, and the Madras. First question arose was, how do we resolve the disputes and on what basis? What should be the law? Mysore very strongly asserted that the rules of international law should apply when the disputes are between the princely state of Mysore and the British India. The reason for this is, or the premise of this argument was, that princely states are independent or sovereign authorities, and therefore any dispute with the British India has to be resolved on the yardstick of international law that is applied between the states in the Europe. But who has to decide what applies? The decision vested with, again, the British government, which has to decide what should apply between one part, that is British India, a directly ruled India, another part, the Indian states or princely states, where they ruled indirectly. The resident in Mysore communicated the decision of the British government and said, the princely states cannot claim application of international law because they do not stand on equal footing with the British government. They are feudatories or vassal states, and Mysore is one such state, and therefore you cannot ask us to resolve the dispute based upon high principles of international law. Then the resident further went and communicated that what applies between the British India and the princely state is the rule of injury, that we shall not do anything which causes injury to the downstream state. So based upon this theory, doctrine of injury, the 1892 agreement was entered into by correspondence. It was styled as rules regulating the limits within which Mysore shall utilize its water. The rule stated, whenever Mysore plans any project, and what type of projects are also defined, the downstream state will decide whether it should grant its consent or not. And while deciding, the downstream state Madras will have regard to whether water is necessary for protecting its prescriptive rights, which are already acquired and existing. In case of a dispute between the downstream Madras and upstream Mysore with regard to the consent, the matter under the agreement was supposed to be resolved by arbitration. So when Mysore decided to construct Krishna Raja Sagara Dam, or it was then called Kannambadi Dam, for two reasons. One was the Kolar goldfields wanted a construction of a dam to augment the flows for power production at Shivanasamudram. Secondly, Mysore thought, if we are constructing a dam for augmenting the flows at Shivanasamudram, why not construct a bigger dam and provide water to the farmers in the drought-stricken Mandya and Mysore? So when Madras objected to the construction of high dam at Kannambadi of 44 TMC, the matter was referred to the arbitration. The arbitrator was Sir Justice Griffiths, who was then a sitting judge of Allahabad High Court. He partly upheld the claim of Mysore for construction of Kannambadi to store about 44 TMC as Mysore wanted, but imposed certain conditions. Mysore was okay. They're happy with the award. But Madras objected to the award and represented to the Governor General saying, arbitration is not final. The British government should have a final say in the matter. But Governor General refused to interfere, saying, a judicial award, I cannot interfere. Then Madras government appealed to the Secretary of State for India in London. Several eminent engineers and barristers were engaged by the Madras presidency to plead before the Secretary of State. The Secretary of State admitted the appeal and directed Mysore giving two options. Either you contest the appeal by filing your objections or renegotiate the matter. At this time, Mr. Vishwesvaraya was the Diwan of Mysore, who was really responsible for reviving the Kannambadi project, which was earlier proposed by some English engineers in Mysore. The matter was renegotiated as directed by the Secretary of State. Then 1921 agreement and 24 agreement were arrived at. The point is, when Secretary of State interfered, under what principle of law did he interfere? Which is very important because that's the principle of law which British government applied later in any dispute between the British India and the princely states. The principle of law is no principle of law, because the British government said, we decide what is good in the greater interest of the people. So whatever the British government decided as a political decision became the law. A dangerous precedent, but that was how it was in those days. Later, some disputes arose between Punjab state and Bawalpur state in northern India. Same, the doctrine of paramountcy was applied. The political decision was taken depending upon what the British government thinks is desirable to be done in the best interest of both states and in the paramount interest of the paramountcy. It is a political decision, not based upon any principle of law. No doctrine of riparianism was applied, no doctrine of harmony was applied, nor the doctrine of equitable apportionment was applied. This is how the disputes were resolved between the British India and the princely states. Besides the dispute on Kaveri and dispute on utilization of surplus water, there are some more minor disputes. Most of them were with regard to the delimitation of the boundary line wherever river was the boundary. One more dispute arose, that was Mulla Parayar. It is not strictly a riparian dispute. The Madras state obtained a lease from the Travancore Maharaja to construct a dam in the state of Travancore and transfer the water to the Madras state or Madras presidency then. Some dispute arose. The matter was referred to the arbitration of Justice Page in 1929. Otherwise, it was governed by the lease executed in 1892. Now let's go to the British India. How did British India resolve the disputes between the provinces within British India? We talked about how the disputes between British Indian province and hello, there is some problem. Hello.
No, sir. Absolutely no problem. We are able to hear you.
Okay. When the dispute arose between the provinces of British India, the question arose, who has to decide and on what principles? Initially, there are not many disputes between the provinces of British India, between one province versus another provinces or presidencies. The first dispute that arose was around 1920, when Punjab decided to utilize surplus water by various projects, particularly Satluj Valley project. The downstream state or a province was Bombay. You will be surprised to know that the Bombay presidency in those days extended from Sindh, which is in Pakistan now, to the Tungabhadra river near Harihar in Karnataka. What we call Bombay state, Bombay, Karnataka, was a part of Bombay state in those days. And that state extended or included Sindh, which is now in Pakistan. So essentially, it became a dispute between the state of Punjab and the Bombay presidency. How to resolve this dispute became a question in those days. Should it be resolved by applying political doctrine as was applied in a decision between princely state and the British India? But it appears those disputes are resolved with a better principle, but again not judicially, by taking administrative decision based upon what is good for both the states. It was not judicial decision, and it was not political decision. It was in between, you can say, an administrative decision where some sort of a principle of natural justice was applied. The states were heard, considered, their views were considered, the decision was taken. Then came the Government of India Act 1935. First time, an adjudicatory procedure was invented. The Government of India Act 1935 first envisaged establishment of Federation of India. The Federation of India included not only the British India, it also included the princely states. So it was an amalgamation. Unfortunately, Federation of India could not be established because no princely state signed instrument of accession in those days. So essentially, the Government of India became the Government of British India. The Government of India Act contemplated adjudicatory process to resolve the disputes between the provinces and the disputes between the British India and the princely states. The procedure was the aggrieved state has to lodge a complaint. The Governor General will constitute a commission of inquiry, a commission, and which will, upon its investigation and on conducting an inquiry, will submit a report, and based upon that, the decision will be taken. One dispute arose, that's the dispute between, again, Punjab and Sindh. By 1936, the Sindh had separated from the Bombay Presidency and was established as a state. In fact, Sindh and Odisha were the two first linguistic states established in India based upon the language. So the dispute was referred to the commission, and the commissioner was none other than great Sir B.N. Rao, Benegal Rao. Benegal Rao was later the advisor to the Constituent Assembly, and whose advices, notes are frequently referred as an aid for construction of the Constitution. Later, Sir Benegal Rao was the judge of the International Court of Justice. Sir Benegal Rao had the occasion to consider the dispute between Punjab and Sindh. And in this report, which is a classic really, cited world around, he considered the law applicable in India in depth. He considered the international law. He considered the law as applied between the two federal states in the United States of America, and finally laid down the law to be applied in India between the two provinces is the rule of equitable apportionment. It's a very important decision. He departed from the earlier approach of the British government that disputes between the two princely states to be resolved by applying the public policy or what is good for both the states generally. But he brought in some sense of legalism by saying that doctrine of equitable apportionment will apply. Then Sir Benegal Rao went ahead, submitted his report, in which he protected the rights of downstream state of Sindh in Indus Delta, that is the deltaic portion of the Indus River below Sakur Barrage, then protected the rights of upstream state, that is Punjab, with regard to its new projects to be taken up for utilization of water in the drought-stricken areas. But somehow, before the report could be implemented and put into action, the political changes took place. The British government decided to enact Indian Independence Act and grant independence to India. And before that, a day before that, India was partitioned as Dominion of Pakistan and Dominion of India. So all this led to the almost frustration of the report of Sir Benegal Rao. Then it is a separate matter how the disputes were resolved between India and Pakistan, because Indus Basin, which was a national basin, became an international basin. Then rules of international law were applied. After a long discussion, the famous treaty, Indus Treaty, was arrived at in 1961. That's a separate matter. So after independence and the enactment of the Constitution in 1950, how did we decide to resolve the disputes? Sir Benegal Rao was an advisor to the Constituent Assembly. He played a role. So as Dr. Ambedkar, who was earlier the Minister for Water Resources, as a member of the Governor's Executive Council before 1945, who was responsible for Damodar Valley Corporation on the lines of Tennessee Valley Corporation, United States of America. At that time, again, the issue was thought over. That is, at the time of making of the Constitution, how to resolve the interstate disputes. Two models were available. One model is adjudicator method, which has already been the method adopted in the Government of India Act 1935. The other was integrated development by creating a corporation of all the riparian states and develop the water jointly. This model was already implemented by Dr. Ambedkar by establishing Damodar Valley Corporation on the models of Tennessee Valley Authority. The Constitution merely said under Article 262 that the Parliament can create a body for resolution of interstate disputes, and Parliament can, if it desires, bar the jurisdiction of all the courts. So it was an enabling provision to deal with interstate water disputes in India under the Constitution of India. It's an enabling provision. Between 1950 to 56, the enabling provision was not really put into action. No law was made establishing interstate tribunal. So naturally, the disputes had to go to the Supreme Court if there is a dispute. Fortunately, there was no dispute. So no dispute really went to the Supreme Court under its original jurisdiction of Article 131. Finally, in 1956, the conundrum was resolved by creating two-tier system. First, the Parliament passed the Interstate Water Disputes Act 1956, providing for the establishment of an interstate water disputes tribunal to the exclusion of the jurisdiction of the Supreme Court of India to resolve the disputes between the two states. The Parliament also passed simultaneously the Riverboats Act, which provided for establishment of a river board if the states agree to develop the water jointly. River board, as I said already, was modeled on Damodar Valley Authority or Tennessee Valley Authority in the United States of America. It was a joint effort by all the states to utilize the water. In case of any differences between the states in the process of utilization of the water, the Riverboats Act provided for reference of the dispute to the arbitrator. So this is one model. The other model is the adjudicator model, that is establishment of a tribunal under the Interstate Water Disputes Act. Unfortunately, what happened is the Riverboats Act was never implemented in India. In a sense, no river board was constituted in respect of any basin in India. So till today, the Act is on the statute book of of Parliament, but no river board has been constituted. The great idea remained on paper. Instead, what the states did was to file complaints under the Interstate Water Disputes Act. Initially, the Planning Commission tried to play the role of mediator in resolving the interstate disputes. For nearly 15 years, from 1950 to 1969-70, the Planning Commission did play an important role in trying to bring the states across the table, but it failed. So finally, in 1969, the disputes started erupting in a crystallized form. Andhra Pradesh, Karnataka, Mysore, then called Mysore, Maharashtra, all filed the complaints with regard to the utilization of Krishna water. Similarly, Maharashtra, Karnataka, Andhra Pradesh, Odisha filed complaints with regard to the utilization of Godavari waters. Another basin where disputes arose was Narmada. The states of Gujarat, Madhya Pradesh, and Maharashtra, and also Rajasthan, though it was not a riparian state, filed complaints for resolution of the disputes by constituting a tribunal. The Government of India Act, as per the provisions, initially conducted a statutory negotiation, and on being satisfied that these disputes cannot be resolved by negotiations, which is an administrative satisfaction, constituted the tribunals. These tribunals were Krishna Water Disputes Tribunal in 1969, headed by Justice R.S. Bachawat, who was then a sitting judge of Supreme Court of India. The second tribunal was Godavari Tribunal, again headed by the same set of judges, that is Justice R.S. Bachawat. Then the third tribunal, Narmada Water Disputes Tribunal, this was headed by Justice P. Ramaswamy, who was one of the few judges of the Supreme Court from the cadre of Indian Civil Service or ICS. Very eminent judge, a scholarly man. So these three tribunals proceeded to resolve the water disputes in the post-independent India, and they submitted the reports in 1973-74. There were back references in Godavari, Krishna, and further report was submitted in 1976, distributing 2060 TMC of water between the states of Karnataka, Maharashtra, and Andhra Pradesh at 75% dependability. I did not go into these disputes in detail, as it is very difficult to deal them in a short time. With regard to the Godavari, the tribunal submitted the report, but fortunately, most of the issues raised in the Godavari water disputes were resolved by bilateral agreement by the parties before the tribunal. So tribunal also played the role of a mediator in bringing the warring states on the table and have them resolved. Then the dispute of Narmada, it primarily centered around the construction of Naugam Dam, the height of the dam, which was finally resolved in 1979 and a further report. And these disputes were in those days, were really resolved by the tribunal because there was no appeal contemplated to the Supreme Court. The parties took the provisions of Section 11 of the Interstate Water Dispute Act seriously, and no appeals were filed. And as a result, the awards or the decisions were implemented by gazetting under Section 6 of the Interstate Water Disputes Act. Thereafter, in 1985, one more dispute arose, that is a resolution of dispute between Punjab, Haryana, and Rajasthan with regard to the waters of Ravi Bass. Since Ravi Bass dispute was sought to be resolved under the agreement of Prime Minister Rajiv Gandhi and Sant Longowal, it is a political agreement that surplus waters will be decided by the tribunal to be established by the central government. Therefore, the central government decided to amend the act to acquire a power to suo motu establish a tribunal and refer to the tribunal 2 points for resolution, that is para 9.1, 9.2 of the Punjab settlement between Rajiv Gandhi and Sant Longowal. This tribunal proceeded very fast. In those days, I used to appear before this tribunal on behalf of the intervener Delhi administration. It was just about 9 months that Justice Aradi, who headed the tribunal as a sitting judge of Supreme Court, gave his report. For several reasons, I don't know. The parties did not lead the evidence. The whole matter was argued on the basis of documents. When the report came in 1987, parties filed application for clarification, explanation, or some sort of a review before the same tribunal, which is provided under Section 5.3 of the Act. And those applications are still pending for various reasons. It is more than 30 years. So the tribunal, which proceeded very fast and is the lowest tribunal in disposing of the pending 5.3 applications. Right. Then in 1990 came the famous Kaveri water dispute. On the direction of Supreme Court, the Kaveri Water Dispute Tribunal was constituted, headed by Justice Chitatosh Mukherjee, who was then Chief Justice of the Bombay High Court. Later, he resigned. He was replaced by then sitting judge of the Supreme Court, Mr. Justice N.P. Singh. The Kaveri Tribunal really took long time, probably the longest, for 17 years. I don't think any other tribunal would take as long as Kaveri Tribunal took. Of course, now the law has been amended. The tribunal will have to give a report within 3 years. This is after 2002 amendment. The Kaveri Tribunal submitted its report in 2007, apportioning 740 TMC of water between the three states. Actually 4, if you consider Pondicherry Union Territory also as a state. Kerala, Tamil Nadu, Karnataka, and Pondicherry. Except Pondicherry, all 3 states appealed to the Supreme Court, and finally the Supreme Court passed its decision, modifying partly the decision of the tribunal in 2018. Now, as the decision stands, 740 TMC stands allocated between the three states in the ratio 284.75 TMC to Karnataka, about 414 TMC to Tamil Nadu, 30 TMC to state of Kerala, and about 9 TMC to Pondicherry. The crux of the matter is how much of water the state of Karnataka has to release in a water year to the state of Tamil Nadu at the interstate border. This is the only obligation in the judgment of the Supreme Court. And this judgment says Karnataka shall release about 177.25 TMC annually at the interstate border, Bilugundulu, where there is a Central Water Commission gauge station to measure. And this 177.25 is split into the monthly quotas. And in case of a distress, the tribunal has provided for sharing of the distress on a proportionate basis. That means if there is a distress of 20% in the basin, if 20% less is available in the catchment in the upstream state of Karnataka and Kerala, they will proportionately give less water. But what is this proportionately less is a debatable question. It's very difficult rather. The US Supreme Court in one of the case relating to the Colorado River very rightly said, pro rata sharing, though appears equitable on the face of it, is not necessarily equitable always. In a distress situation, how the state should share the water is again an exercise of reassessment of the needs, depending upon the priorities, etc. Therefore, whenever there is a distress situation in the Kaveri Basin, you always hear a lot of acrimony, lot of debate on what is the share of Karnataka and what is the share of Tamil Nadu, how much Karnataka should release or should not release. There have been intervention by the Supreme Courts at various times in 95, 96, 2002 and 3, 2012 and 13, 2016 and 17. But all these interventions were again based upon ad hoc principle. None really attempted to define what is this proportionate sharing of water means or pro rata sharing of water means. It remains still an unresolved question. Now the Krishna water dispute. Krishna water dispute was resolved by the Tribunal 1, but the question came up with regard to the surplus water. Surplus water was distributed by the tribunal as a recommendation of the Scheme B. When the parties did not agree to implement Scheme B, when Karnataka wanted to implement Scheme B to utilize water by constructing Almaty Dam up to 524.256, the matter went to Supreme Court. Supreme Court permitted Karnataka to store water up to 519.6 meter. Then Supreme Court said the question of storing beyond 519.6 meter up to 524 depends upon the decision of the tribunal to be constituted by the Government of India to distribute the surplus water. The tribunal was constituted in 2006, headed by Justice Brijesh Kumar. Bachawat headed the previous tribunal, Krishna 1. And Brijesh Kumar gave his report in 2010 and the further report in 2013. He upheld the claim of Karnataka for storing up to 524.256 meters and construction of dam and utilization of water under Almaty or Upper Krishna project out of 302 TMC. In total, Karnataka's share was increased from 734 TMC as given by the Bachao Tribunal in 1976 to 907 TMC by Krishna Tribunal 2. So as the share of Andhra also increased and Maharashtra. Karnataka and Maharashtra are the real beneficiaries. The appeal has been filed in the Supreme Court and a matter is pending. We need not say much. So besides this, Krishna, Kaveri, two more tribunals were constituted in the recent past. One was Vanshadhara Water Disputes Tribunal between the state of Odisha and the state of Andhra Pradesh with regard to the construction of a barrage and construction of the sideway. There are no sharing of water involved in this dispute. This dispute primarily concerned with regard to the extent of submergence which might occur in the state of Odisha if the state of Andhra Pradesh were to construct the barrage called Naradi Barrage across the river Vanshadhara, where river itself is a interstate border. There is also a question whether on the right side of the river, it is open to the state of Andhra Pradesh to cut and take the water. So this is Vanshadhara. The report was given by the tribunal. It was constituted in 2010. The report came in 2016, I think, 17. I was appearing for the state of Odisha. And there is an application under section 5.3 pending now. After this, one more tribunal has been constituted. That is Mahanadi Tribunal to resolve the dispute between the state of Odisha and the states of Chhattisgarh, Madhya Pradesh, Jharkhand and Maharashtra with regard to the utilization of the waters of river Mahanadi. The dispute is in the initial stage. Justice Khanwilkar, sitting judge of the Supreme Court, has been heading the tribunal. So these are the disputes in India. This is how the interstate water disputes have evolved in India. Initially started, as we saw, the disputes between the province of British India and the princely states. There are disputes within the provinces of the British India. Then after independence, a thought was considered whether we should resolve it by adjudicator process or by the integrated management process by constituting a river board. The law was passed for both, but unfortunately no river board has been constituted. So states have been resolving the disputes by resorting to the adjudicatory process, that is submitting to the jurisdiction of the tribunal. And tribunals have given report or given their decisions. The Supreme Court has been interfering under Article 136 of the Constitution by asserting its jurisdiction with regard to the legality of the award. Section 11, which barred the jurisdiction of all the courts, was interpreted by the Supreme Court, and I feel correctly, that what is final is only with regard to the merits of the dispute, but not with regard to the legality. With regard to the legality, the Supreme Court will have the last word. What is legality is a different question. But to that extent, the Supreme Court has retained its jurisdiction. So the final word in India is the Supreme Court. This is how the evolution of the dispute has taken place from 1850 to 2020. These interstate water disputes are very complex. Complex in law, complex on facts also. Lot of thinking, lot of cooperative work is necessary between the engineers and the lawyers to build up the case. The facts are complicated because the science of hydrology is an applied science, so as hydraulics. The law is also bit vague. The rules of equitable apportionment are not capable of precise definition. As a result, you see prolonged disputes, but still the disputes can be speeded up if the states show cooperation. And I'm sure in days to come, with the better science, better infrastructure available, the resolution of the dispute will be speeded up. In fact, the government of India has proposed for constitution of the permanent tribunal. Bill has been introduced to the parliament. It was passed in the Lok Sabha, but it is yet to be considered by the Rajya Sabha. If the bill is passed, it will lead to the establishment of permanent tribunal. So, water dispute become any other dispute. Of course, court will not have compulsory jurisdiction. It has to be referred by the government of India on being satisfied that the dispute cannot be resolved by negotiations. Thank you very much for having the patience to listen to this subject. It is a bit dry subject. I could do my best to present it within a short span of 1 hour. I'm sure you all enjoyed. Thank you very much. Thank you, Mr. Ranganath. Thank you all. Thank you.
Thank you. Thank you, sir, for a brilliant session. Praveen, request you to unmute Mr. I.P. Ranganath, our president.
Sir.
Yeah. Yeah, I'm listening.
Sir, namaste. Thank you very much, sir.
Thank you. Thank you. I must thank you for giving an opportunity to speak to the people of Karnataka,
please, sir.
and particularly to the lawyers in Bangalore and engineers in Karnataka.
Yeah. Thank you, sir.
Is there any question over here?
Yes, sir. We have a Q&A session now. Before that, it's not just confined to the members of the bar in Bangalore. We have people logged in from various parts of Karnataka and, in fact, various parts of India today. It's not just
That's true. A lot of my engineer friends are logged in, I believe. Yeah.
Many engineers, many lawyers, many non-lawyers, law students.
Okay. Oh my.
All right. With your permission, sir, let's move on to the Q&A session now. Praveen, I request you to unmute the lines. If any of our viewers have any question, they can put forth to our beloved speaker.
Yeah, please.
Parallel, you can also put forth your questions on the Q&A box offline. Praveen.
Unmuted. Yes.
All right. Yes, can we go with the first question, please?
Yeah.
So the lines have
been
unmuted. You will have to unmute yourself and you can put forth your question. All the lines have been unmuted. Anybody has a question, you can unmute yourself and you can put forth your question.
Hello, sir. Good evening.
Yeah, good evening.
This is Suresh. Sir, I must first of all congratulate you for having given the intense and thorough information about the water disputes right from the ancient time till 2020.
Yeah.
Sir, my question to you is, sir, from with your vast experience in this water field, sir, do you think that the equitable distribution of water between the two states would be the correct way of resolving the dispute? If not, what would be your best suggestion, sir?
Yeah. So before the equitable apportionment principle came in, I already said there was a principle of that is doctrine of sovereignty, also known as Harman doctrine, and opposed to that There's a doctrine of riparianism or natural flow theory. Both are extremes, and the via media came in the equitable apportionment. Equitable apportionment appears very nice, very attractive, but it's not that easy to implement. The equitable apportionment requires consideration of several factors and what weightage to be given to the factors. And in the process, the real fight comes between the importance of the existing utilizations and the rights of states to develop new projects. On several principles of what is just and fair, courts have tried to resolve this, but there have been always arguments or objections to the decision making on this difficult principle. But if you ask me if there is any other principle which can resolve the interstate water disputes, I don't think so. All that we can expect is a further refinement of the principle of equitable apportionment, so that the interest of upstream state, usually representing the new users, and the interest of the downstream state representing the existing users are finely balanced and justice is done. Thank you.
Thank you for the thorough information given to us, sir. I congratulate you once again. Thank you very much, sir.
Thank you.
Thank you, sir. Do we have any more questions? I request all the learned members to unmute unless you are asking a question. I repeat, I request all the learned members to unmute yourself unless you are asking a question. All right. Do we have any more questions to go?
Excuse me, this is Professor Suresh Nargodar, Principal, University Law College, Bangalore University. I would like to ask a question to
Yes,
Mohan
Professor,
Katarki.
please go ahead.
Yeah, sir, good evening.
Good evening.
Congratulations for a very informative speech on interstate water dispute. Since I hail from North Karnataka, I would like to know about the status of Madai River dispute at present.
Oh, somehow in the short span, I just missed to mention about Madai water dispute.
Yeah.
My apologies. See, Madai water dispute is between the states of Karnataka and Goa. The tribunal is headed by Justice Panchal. The tribunal has given its report permitting Karnataka to divert certain quantities of water under the projects, namely Kalsa Bandura project. And it has also given right to Karnataka to generate hydropower on the run of the river basis, with some storage also, in fact, at Madai hydroelectric project. The state of Karnataka and Goa have both appealed to the Supreme Court for larger water. The matter is pending in the Supreme Court. In the meanwhile, the government of India has implemented the report, the decision of the tribunal under section 5.2, and therefore now the state of Karnataka is at liberty to utilize its share of water, and there is no stay from the Supreme Court on the decision of the tribunal. Thank you.
Okay, thank you very much, sir. I know that there's a lot of contribution from you and other advocates from who have appeared fought the case on behalf of the government of Karnataka. Thank you very much.
Thank you. Thank you.
Thank you, sir. Do we have any more questions before we wind up the session?
I'm a research scholar from University Law College, sir.
Ma'am, we are
Yes.
not able to hear you.
Sir, thank you, sir. Thank you for your enlightening words, sir. Sir, I would like to know the impact of interstate river water dispute on federalism. How it is impacted? Can you please?
Yeah. See, the resolution of dispute by compulsory adjudication is a facet of federalism. The federalism, as we all know, envisage division of power between the center and the states and between the states. When a dispute arose, if the disputes arise between the states or between the states and the center, there has to be an independent authority to resolve those disputes. This is a facet of federalism. When the Government of India Act 1935 decided to introduce, in the form they understood at that time, the concept of federalism by giving autonomy to the provinces, it became necessary to create an independent judicial body to resolve the interstate disputes. And that power was vested in the federal court. And with regard to the water disputes, that power was vested in the Governor General, who shall decide based upon the report of the Commissioner. And Commissioner was a judicial authority. So this adjudicatory process is a part of the, or a facet of the federalism, which is very essential and which we see in the United States of America also. If the two states cannot resolve the dispute, which American Supreme Court very beautifully put up, if two states cannot resolve the dispute, you cannot expect them to go to war, because states cannot resolve their disputes by war, as independent or sovereign states do resolve the disputes, because war is the ultimate solution. But such a provision is not there for the states within the federation. Therefore, it necessarily calls for an independent adjudicatory mechanism, and that is the Supreme Court of US, and in India, the Supreme Court of India, or a separate tribunal established under the Interstate Water Disputes Act as provided under Article 262 of the Constitution.
Thank you, sir.
Thank you.
Thank you, sir. Thank you, sir. Thank you very much. My sincere thanks to you, sir, for today's webinar. Thank you for enlightening us. Thank you for everything.
Thank you.
Very only. Why it's very.
So with your permission, sir, we'll be logging off the session.
Yeah, you. Thank you very much.
Thank you.
Thank you.
Thank you, sir.
Thank you, sir.